one and all. Namaste. I am Dr. Advocate Sai Sushant from Hyderabad. It's a real honor and privilege to present uh, before you today, and I'm extremely happy and delighted to host the event today, the memorial lecture in the name of my grandfather, Samudrala Krishna Murty. And we have a very interesting day and interesting program. And before we get into the program, I would just like to talk two things about myself because I just wanted to introduce myself. Um, well, when one talks about being the third generation lawyer in the family, the normal euphoria that gets created is that everything that the person has comes from the perch. But this idea fell off with respect to me when I developed tremendous passion towards uh, information technology and technology related legal matters, which virtually paved way for setting up my own independent practice and my law firm. And it's a decade since I got into this practice. With the blessings of God, my family members, support from my uh, family members, my parents, my grandfather, grandmother, everybody. So it was a great journey, and I also like to quote one of the hilarious instances that I had with my mentor, Sri Advocate Shyam Padman sir, who's already part of this August Assembly, uh, where one of his famous anecdote was that a specialized lawyer is one who has more and more knowledge of less and less things. So coming back to that, I was always interested in technology, which is an ever evolving paradigm, and that being so gave me a new vista of coming up with the different subdisciplines of the cyber law and cyber security related legal matters. Thank you so much, sir, for that anecdote, and then for all the conversations that we had since the time I began my professional journey in 2012 after completing my master's. So thank you so much for that. And this is a brief background about myself. And today it's a great privilege and honor for me to host this and program and be a host in this August assembly. And thank you so much, Shyam sir, for extending your platform courtesy of Letters and making this event possible. Without your support, I don't think the online infrastructure and the kind of effort that you have put in, this program would be, I mean, ever possible. Thank you so much. And at the outset, I would like to extend my welcome on behalf of my family as well as on behalf of everybody to Honorable Justice Shri V. Rama Subramanian sir, without whom today's program would have not been possible. Thank you so much, sir. And also, I would like to extend my welcome to Honorable Justice Challa Kodandram sir, without whom today we wouldn't have had this program. And I would also like to extend welcome to Honorable Justice Anil Kumar sir, without whose support we would have not had this program today. And to all the participants of this program, and also and also to Shyam Padman sir for all the support and also for rendering for the technical support, and to all the team of Lettils who have been helping us with the platform, and who have been doing a lot of technical, I mean, who have been helping us with the technical support for making this program live on this platform, and also recording the same and then putting it up on the Lettils YouTube channel. So thank you so much to the Lettils technical team from our side and from the side of my family. So before we get into the program, I would like to just give you the format of today's program. So the format of today's program is this way. Uh, just one second, please. we have the Ganesha Slokam being rendered by Sri Kalaimamani, Dr. Madhu Balakrishnan sir, an renowned Indian playback singer, and then followed by the welcome address by Suribabu Samudrala sir, Advocate, High Court of Telangana and Andhra Pradesh. Then we have the speaker introduction by Honorable Justice Anil Kumar sir, Judge, High Court of Telangana. Then we have the introductory remarks by Honorable Justice Sri Challa Kodanda sir, Judge, High Court of Telangana, retired. Then we have Honorable Justice V. Rama Subramanian sir, Judge, Supreme Court of India, retired, who will be our today's speaker, and he'll be addressing upon the topic emerging trends in judicial reforms. Then we have the concluding remarks by Sri Shyam Padman sir, Advocate, High Court of Kerala. Then we have the vote of thanks by Sri Suribabu Samudrala sir, Advocate, High Court of Telangana and Andhra Pradesh. So this is the format of the program. So without delay, I mean, let's start with invoking the blessings of God. Unfortunately, Madhu Balakrishnan sir, he's a renowned playback singer who's got stuck in an emergency recording. So he has shared the audio to be played in this event, and he has wished the event all the success. So may we just invoke the prayer song.
गणपतिं मनसा स्मरामि महागणपतिं मनसा स्मरामि महागणपतिं मनसा स्मरामि महागणपतिं स्मरामि महागणपतिं मनसा स्मरामि महागणपतिं वसिष्ठवामदेवादिसंहितमहागणपतिं वसिष्ठवामदेवादिसंहितमहागणपतिं महादेवसुतं महादेवसुतं गुरुगुहनुतं महादेवसुतं गुरुगुहनुतं महादेवसुतं गुरुगुहनुतं महादेवसुतं गुरुगुहनुतं आरकोटि प्रकाशं शान्तं महादेवसुतं गुरुगुहनुतं आरकोटि प्रकाशं शान्तं महाकाव्यनाटकादिप्रियम् महाकाव्यनाटकादिप्रियं मूषिकवाहनमोदकप्रियं महाकाव्यनाटकादिप्रियं मूषिकवाहनमोदकप्रियं महागणपतिं मनसा स्मरामि महागणपतिं वसिष्ठवामदेवादिवर्तितमहागणपतिं मनसा
Thank you so much, sir, for that wonderful song on Lord Ganesha. Over to Sri Suribabu sir for the welcome address.
Hello. Good evening, everybody. I'm extremely sorry for the inconvenience and the delay caused in the issue. Honorable Justice V. Ram Subramanian sir, retired Judge of the Honorable Supreme Court of India, Honorable Justice Sri Challa Kodanda, retired Judge of the Telangana High Court, Honorable Justice Anil Kumar Jukanti, Judge Telangana High Court, Honorable Justice T. Vinod Kumar, Honorable Judge Telangana High Court, Honorable Lakshmi Narayan Garu, Judge Telangana High Court, Honorable Justice U. Durga Prasad Rao Garu, Honorable Judge Andhra Pradesh High Court, Honorable Justice Raghunandan Sir, Honorable Judge Andhra Pradesh High Court, and ladies and gentlemen, senior advocates and my brother colleagues. On behalf of myself and my family members, I extend a warm welcome to you all for this event. This is the first event which is being organized in connection with my memory of my father, late Sri Samudrala Krishna Murty, whose birthday falls on 16th August 2023, 90th birthday. My father, late Sri S. Krishnamurti, was born in the year 1933 to my grandparents, Sri late Surinarayana and late Srimati Pichamma at Muktinutalapadu village in Ongole, Prakasam district, Andhra Pradesh. After graduating from Andhra University, he joined as a lecturer in CSR Sarma College at Ongole, and in the year 1956, he joined as a direct recruit commercial tax officer in the government service, the United State of Andhra Pradesh. Since then, he rose from the commercial tax officer to the assistant commissioner, to the deputy commissioner, managing director of AP Fisheries Corporation, chief executive officer, Khadi and Village Industries Board, then joint commissioner, commercial taxes, member of the sales tax, AP Sales Tax Appellate Tribunal, and joint commissioner, CT Legal, and the demoted office in the year 1990 on 31/1/1991, and he was as a department member of the Sales Tax Appellate Tribunal. He has rendered various decisions, which were on 90%, which were affirmed by the Honorable High Court as well as the Supreme Court. And he had he chaired the bench with Honorable Justice M.N. Rao, retired Chief Justice of Himachal Pradesh High Court, Honorable Justice Neeladi Rao, Honorable Justice B. Sriramulu Garu, who retired as High Court judges. During his tenure as the working in the commercial taxes department, he has authored books on sales tax, numbering 12, and all the 12 books which he has authored they are being followed by department officers, the legal fraternity, the judiciary, and the trade at large across the country. On the abolition of on the repeal of APGST Act and on introduction of AP Value Added Tax Act in the state of Andhra Pradesh, which is a new concept in the entire country. He has conducted various workshops, conducted various seminars to bring about the upcomings, the infirmities and deformities in the enactment of AP Value Added Tax Act 2005. Now, the first book on it is not out of context at this hour to bring on record. The first book which is authored, namely Case Law on the Central Sales Tax Act and the compendium of Central Sales Tax Act, which he has authored. It was mentored with Justice P. Venkataramaredi, retired judge of the Honorable Supreme Court, as he then was as an advocate. And we thank you very much, sir, for all the support which you have rendered to my father. The first book which he has authored, namely Compendium of Central Sales Tax Act, has been donated to to His Holiness Jagadguru Sri Pujya Sri Kanchi Paramacharya, then Kamakoti Parama of Kanchipuram, and all the subsequent books were also dedicated to the subsequently to the Acharyas of Swamiji of Kanchimat at Kanchipuram. His association with the Kanchimat made him as the administrator of the Kanchimat at Srisalem, where he has done his illustrious service to the upliftment of the temple of the trust almost for 27 years. And he has contributed almost about 60 to 70% of his professional income for the development of the trust. I am extremely sorry because I am unable to I'm unable to speak out for the reason that I'm remembering my father. I'm extremely sorry for that because I'm not able to proceed further.
So we understand your emotions, please.
In fact, he has contributed a lot by providing, the Vedic education to Brahmin children, besides running the Goshala at Srisalem Mutt. And majority of his savings from, including his pension amounts, were donated to the trust. And then he had also constructed around 20 rooms and also Yagasala and Bhojanasala at Srisalem, and had performed a lot of yagas at Srisalem, and his interest in spreading about all the four Vedas enabled him to get a lot of things across the Vedic aspects, and then he went on to also host many programs relating to Vedas on the television, which ran for a lot of years, and he attained Shivaikyam on April 28th, 2021. So it was a very emotional moment. For all of us, but still, in the name of, his in his memory, we thought this memorial lecture series should be the initial way of how we could actually try to put forth our gratitude towards him and his service. So thank you so much.
Let me also tell one thing, please. No, his commitment to Sanatana Dharma is his contribution to Sanatana Dharma was to the extent of all the four Vedas were got recited at the Srisalam temple by all the Vedic Gana parties, and all of them were got recorded, and still they are stored in our in our house, and they were telecasted in the TV almost for about a year. His contribution to the Sanatana Dharma was marvelous, and we are still following his footsteps by maintaining the Vedic school at our native place at the Mukti in Bengal, and wherein almost about 25 to 30 students are imparted training in Vedas and Sanatana Dharma. We are still continuing the tradition, and we hope that we will do our best
to continue his legacy, both in the profession as well as in the upliftment of Sanatana Dharma. Thank you so much, Suribabu sir. It was a very, very concise and very emotional speech. Thank you so much for the welcome address. We are really honored. Thank you so much, sir. Now, may we go to the next item? Now, may we call upon Honorable Justice Anil Kumar sir, the judge, Telangana High Court, for the speaker introduction. Over to you, Anil Kumar sir.
Namaste to Honorable Justice Rama Subramanian sir. And good evening to all the colleague judges and also to everyone. Thank you, Sushant, a privilege and honor for me to speak of Honorable Justice Rama Subramanian sir, former Judge, Supreme Court of India. Lordships were born in the year 1958 at Mannargudi, Tiruvarur district of Tamil Nadu. Graduated from Ramakrishna Mission's Vivekananda College, Chennai, and having obtained a law degree from Madras Law College, Lordship started his practice by joining the office of Senior Advocate Sri K. Sarvabhouman and Sri T.R. Mani from 1983 to 1987. Lordship started his own practice from 1987 to 2006. And in the year 2006, Lordships were elevated as Judge, Madras High Court. On 27th April 2016, Lordships were transferred to the combined High Court for the state of Telangana and the state of Andhra Pradesh and took over as Judge of the Telangana High Court and subsequently was elevated as Chief Justice of Himachal Pradesh High Court and had assumed charge on 22nd of June 2019. Thereupon, Lordships were elevated to the Honorable Supreme Court of India as Judge, Supreme Court of India in 2019 and demitted the office as a Judge of Supreme Court of India on 29/6/2023. Lordships, beside being an illuminary, being a legal luminary, Honorable Justice Rama Subramanian sir was a great columnist and was also a versatile Tamil literature. Lordships has authored a book titled Principles of Law and Justice in the language of Tamil, which had strings from Kumbha Ramayana. He is also an alumnus of Sri Satya Sai Bala Vikas attached to Bhagwan Sri Satya Sai Baba Institute of Learning from the state of Tamil Nadu. As a judge of the Honorable Supreme Court of India, Lordships have delivered several landmark judgments. As a judge, Lordships, some of the important judgments of Lordships were on Internet and mobile. One is Internet and Mobile Association versus Reserve Bank of India, which dealt with the cryptocurrency. And one of the other important judgments was decision in Consim Info Private Limited versus Google India Private Limited, where infringement of trademark by an internet search engine through its AdWord policy was also extremely beneficial to the Society of Advocates. A decision in Rajashri Sugars versus Axis Bank on the validity of derivative contracts, first of its kind in the country. In Colgate Palmolive versus Anchor Toothpaste, Lordships have delivered a judgment pointing out that consumer interest is of paramount interest and hence companies are responsible for any misleading advertisements. In another judgment of its own kind, Vandana versus Srikanth, the decision of shared households are expanded for the first time, besides Supreme Court taking a view in Batra versus Batra, which decision was hailed by many women organizations. These are a few of the judgments which my Lordships have rendered during Lordship's entire career as a judge. Now I take the honor of passing on the next speaker, Honorable Justice Challa Kodanda Garu. Sir, thank you, sir. It was an honor speaking about my Lordships. Thank you very much, Lordships.
Good evening to Learned Senior Justice Ram Subramanian Garu and also other learned judges, as well as all the participants who are assembled today through this virtual meeting. I have been given an envious task of introducing a subject which I hardly know about. And that too, I was always, in fact, I've been thinking on that subject from morning. And one of the things which came to my mind was, it's like that too, speaking before Justice Ram Subramanian itself is intimidating. And now with galaxy of lawyers and also the judges sitting as well as the retired judges, my performance would be something like Hanumantunu Mundu Uppigantulu. So I was slightly hesitant. Then the topic which has been chosen is something very tricky from the perspective of the context of the Indian society. With respect to the world over, maybe the technology is the dominating, and the technology is virtually taking over with respect to judicial system and judicial reforms. But when we think about India, though we pride ourselves, I'm being very open and I'm also putting a lot of thoughts which I would like to. I have an opportunity to speak to the galaxy of people who really matter in this system. And probably I also I sure expect this Ram Subramanian to think over and also to ponder over and also may give some insights and also the future generations to come from the context of Indian society. So far as the emerging aspects in the judicial reforms are concerned, you all know it's available on the net. Artificial intelligence, the power of research, which most of our youngsters are able to use today. With the click of a button, they can bring out a precedent from plethora of precedents, and also straight away point out to that particular para where the issue is either discussed or decided. Many a time we really get confused, and we also have the habit of taking passages of discussion and then thinking that is the ratio. Be it as it may be, but the issue is that the ease with which we can pick up a precedent and the site before the court has been made much more simpler. I cannot say that it's an emerging trend. It is already in vogue now today. Then when it comes to there's a usage of the blockchain-based smart contracts. In fact, I had an occasion in the few hours back to have a conversation with the Vice Chancellor of Hidayatullah National Law University, Dr. Vivekananda. He was sharing with that one of his the college alumni had developed the portal or in a company, quite a big company, wherein something called contract spot or something like that, where with respect to any kind of contracts, the required input is given, it instantaneously generates a contract, whichever country you require, depending on the laws of that particular country and also need of the other. And I understand that but he had also suggested that he will put me into contact with that particular person. It's a very interesting concept. Thereby, his opinion is that over a period of time, the requirement of the lawyers will, over a period of time, will virtually get reduced, as is happening and happened in India, in the US. Then with regard to the virtual and augmented reality which we are facing, in fact, this is one of the example, our meeting itself is one of the example. And during the pandemic, the kind of work which to the high courts as well as the Supreme Courts, a majority of them have turned out, is something extraordinary. There was a time where many of our judges in Telangana High Court were sitting up to 8 o'clock, 9 o'clock, because they were not knowing the time. They were in a confined room and they are in an AC room. The lights are on. They do not know the difference between the day and night. And on the screen, the one after the other advocates who are in the listed, they are coming and they are going. They are coming and they are going. With the result, the judges also were not really were not aware of the time which they were spending. It's something remarkable which has happened. Maybe that again can be adopted. Then you also know the big data analytics, which is playing a key role in fetching the data as well as analyzing the data. And then there's also something called predictive analysis. In fact, about 3-4 years back itself, this has come. The interesting aspect which I was privy to and shared by a few of my friends from abroad as well as India is, many of the companies today, and especially the people who have the data, they have the tools to predict how a judgment is going to come from a particular judge, basing on the previous judgments here the judge has rendered over the years. Virtually, it gives the accuracy rate is about almost 80-90%. Whatever may be your, irrespective of the arguments which you may advance, irrespective of the material which you may produce, in a particular there's a pattern which the artificial intelligence could be able to make this thing that is called the predictive analytics. That's the word which has been given. Then with regard to the cloud-based document management, this is also in vogue. All these point out usage of the technology. But the question which I have in my mind with regard to, and also the problem which perennially I am being troubled is one of the videos which has recently, which was an open discussion which has made. We think about only what is happening in the courts, the matters which are pending in the courts. But in that particular meeting, the individuals, what the mind-boggling statistics were thrown out with respect to various other forums which really do not are not the courts, but are it could be tribunals at the level of the taluka level, at the level of the joint collector, at the level of the tahsildar. If all these aspects are taken, the majority of the time, how an individual gets entangled in the legal battles at one point or other with respect to various aspects. And that wasn't present to many of the lawyers or the judges. To be honest, in 8 years of my service, I never felt, there are so many thousands of cases which are pending before the joint collector, before the tahsildar, because in the High Court, we are only 8 or 10 or 30, 32 or 40 people. But imagine just the number of tahsildars, imagine number of RDOs, imagine number of the collectors. Then with respect to various other departments and a large number of cases pending before them, which are not getting decided. With the result, they rush to the High Court asking for a mandamus, dispose of this matter, that court of this matter, virtually converting High Court into a consider and dispose of jurisprudence court. I'm being little open, and it's something to think over for many of our the brother judges, and also I look forward for this aspect of the matter also from the Indian context. Any amount of technology is really not going to help solve this problem. Any amount of the number of judges being there also would not solve this problem. And the way one looks forward is one of the suggestions at one point of time, which I had occasion to discuss with Justice Totatal Radhakrishnan, our former Chief Justice, was at the stage of High Court, why not they make the concerned state actors, that is, it could be a secretaries or it could be a particular department where a large amount of the work gets generated, responsible before a person could approach the court. In fact, he took the suggestion in a right earnest, and he wanted to constitute a committee, and he wanted to call the concerned secretaries as well as the chief secretaries. Unfortunately, thereafter he got transferred, and then the idea went into the storeroom. From the Indian point of view, we all will be delighted to have what exactly is going to come. Emerging trends are there will be more lawyers, more number of judges, and as we go along, there are also more number of cases. But without first we analyzing why the cases are coming, where is the fault lies? If you look at the overall litigation, so far as the High Courts is concerned, 98% or 80% is the litigation by the government or against the government. And so far as the district courts are concerned, subordinate courts or the district courts or the subordinate courts are concerned, the matters are of today there are not many matters where large amounts are involved. They're all petty matters or the matters which really could be settled if we do not follow a particular pattern. And this is all in spite of there being a Lok Adalats, in spite of there being a periodical various other methods through which we have been trying to solve the problem. It's really mind-boggling, and as a lawyer, yes, it is definitely something which we all look forward, and there is some element of bread with butter for me. But as a citizen and as an individual, I feel sorry what's going to happen. These are my thoughts. I thought I'll share frankly and leave to the Leonard senior brother to enlighten us. And I'm sure that he will have something from the epics as well. I'm sure that it's not that this problem is cropping up in this particular yuga or generation. Maybe from somewhere it has also be there in different forms. Thank you very much for this opportunity of sharing my thoughts openly.
Thank you, sir. Thank you so much, Honorable Justice Kodandram sir, for sharing your insights and introducing your thoughts into this August Assembly. Thank you so much, sir. Now, on behalf of the office of Sri Suribabu Samudrala sir, I hereby invite our speaker today, Honorable Justice V. Rama Subramanian sir, the Judge, Supreme Court of India, retired, to render his, and enlighten us with the topic emerging trends in judicial reforms. Over to you, Ram Subramaniam sir.
Thank you. Honorable judges of the Andhra Pradesh High Court, honorable judges of the Telangana High Court, former judges of the High Courts of Telangana, Andhra Pradesh, Kerala, I don't know who else is there, respected senior advocates, Mr. Suribabu, Mr. Sushant, and other family members, my dear young lawyers. We normally invoke Lord Ganesha to remove all hurdles, vignams. But today, Lord Ganesha himself created a hurdle. That is probably the hurdle created by technology to Lord Ganesha. So I think we have had different forms of Ganesha. I don't know whether we have Lord Ganesha sitting before a computer. It is yet to come. We have had dancing Ganesha like Buddha. We have had different forms of Ganesha. I think we'll have to have Lord Ganesha sitting in front of the computer. Today is there is a very strange coincidence. I was introduced by a person who has just got into the judiciary, and he introduced a person who just got out of the judiciary. Justice Anil Kumar is just 13 days old in the judiciary. He got in 13 days before. I got out 15 days before. I used to say that, there is a Tamil proverb which says that marriage is a strange prison in which people inside want to get out and people outside want to get in. Judiciary, I always used to say, is also a similar prison where people outside want to get in and people inside want to get out. Dear friends, I feel delighted and honored to have been invited to deliver this Samudrala Krishna Murty Memorial, first memorial lecture, for more reasons than one. I am perhaps the only person among those present on screen, with perhaps the exception of Justice Challa Kodanda, who have known 3 generations of the Samudrala family. Sri Suribabu used to appear before me day in and day out for 3 years during my stint at the Hyderabad High Court. Sri Sai Sushant, Dr. Sai Sushant, Suribabu's son, is an excellent technocrat and a lawyer. I have had the pleasure of reading some of his articles and books, though I cannot claim to have understood all of them fully. In fact, Dr. Sushant has authored quite a few books, such as Websites and Indian Cyber Law, Chatbots and Law, Telemedicine and Law, Cyber Security and Medical Legal Perspective. In fact, one of his books, one of Dr. Sushant's books, is on corporate cyber learnings in Ramayana. I have had a very chance encounter with Samudrala Krishna Murty, perhaps in the year 2017-2018, when I went to Sri Salem. After having darshan of Mallikarjuna Swami and Brahmaramba, I was returning to the guest house. On my way back, I saw someone standing outside the Kanchi Kamakoti Mutt. I did not know then who that person was. He introduced himself as Samudrala Krishna Murty, father of Suribabu. He introduced himself as the father of Suribabu. He took me inside the mutt, showed me the temple and the Goshala. He was very passionate about being associated with the activities of the mutt, and he impressed me as a person who was at that time in the Vanaprastha ashrama of his life. I think me and Challa Kodanda are also at that stage, but we have some filial duties to perform. Therefore, we have not gone on Vanaprastha. About the achievements of Samudrala Krishna Murty, Mr. Suribabu has presented a very emotional picture. Therefore, I don't think I can dwell more on that. So let me straight away get into the topic about which Justice Challa Kodanda gave a very interesting introductory perspective. The topic we have chosen for today's discussion is emerging trends in judicial reforms. The judicial system is the most expensive machine ever invented for finding out what happened and what to do about it, said Erwin Kaufman. As it happens quite often with every machine, the judicial system also suffers from the problem of breakdown at times. It also requires repairs and maintenance and periodical servicing and overhauling, this judicial administration machine. The attempts at overhauling the system of administration of justice are what are broadly termed as judicial reforms. For easy appreciation, I shall divide this topic into 3 parts. The first part, providing an overview of the reforms that were attempted in the past. The second part, dealing with the use of information technology as has been projected by Justice Challa Kodanda. And the third part, dealing with the issue of appointment of judges, which has become the most contentious issue throughout the world. Now let me take the first part. Traditionally, every attempt at judicial reforms focused on streamlining court procedures and the processes, prompt filling up of vacancies, effective utilization of human and material resources, reduction of arrears, improving access to justice, provision of legal aid, etc. This is how traditionally judicial reforms were conceived to be. The very first Law Commission of India, constituted in September 1955, took upon itself the task of investigating the system of administration of justice in the country. This first Law Commission submitted its 14th report in September 1958. This 14th report of the first Law Commission was titled Reform of Judicial Administration. The suggestions made by the Law Commission in its 14th report were aimed at achieving two objectives, namely, number one, speedy justice, and number two, providing a less expensive system of administration of justice. So that is how the journey into judicial reforms commenced post-independence from the year 1958. Exactly after 51 years of the submission of the 14th report of the Law Commission, the Law Commission of India submitted in the year 2009 its 230th report titled Reforms in the Judiciary, Some Suggestions. But this report also addressed only peripheral issues such as effective utilization of court working hours, bunching and grouping of similar cases for easy disposal, curtailment of vacation of courts, lawyers' strikes, etc. These are only peripheral issues. Docket explosion and the choking of courts with huge pendency triggered at one point of time what we now call as tribunalization of justice. Interestingly, the process of tribunalization of justice started way back in 1941, pre-independence, with the creation of the Income Tax Appellate Tribunal. Subsequently, we have had any number of tribunals. The total number of tribunals established under various enactments increased to 26 over a period of time. But the remedy of creating tribunals proved to be much worse than the malady. While the creation of more tribunals did not result in reducing the arrears in courts, the tribunals themselves could not cope up with the workload. For instance, as of March 15, 2021, the Central Government Industrial Tribunal cum Labour Courts had 7,312 pending cases. As of February 28, 2021, the Armed Forces Tribunal had 18,829 pending cases. And as of January 1, 2018, the Income Tax Appellate Tribunal had 91,643 cases. Therefore, through the Finance Act of 2017, a reorganization of tribunals took place, and the number of tribunals were brought down from 26 to 19. But the rules framed under the Finance Act 2017 were struck down by the Supreme Court. Thereafter, the Tribunals Reforms Act 2021 was passed. Under Section 33 of the Act, very interestingly, all of you should know, under Section 33 of the Tribunals Reforms Act 2021, all those appointed as chairpersons, vice chairpersons, presidents, vice presidents, members, etc. of the tribunals listed in the second schedule to the Act were declared to have ceased to hold office with immediate effect. Suddenly, there was a sudden termination of the services of all of those who got appointed as quasi-judicial officers. But the section 33 provided only one remedy, namely that these quasi-judicial officers were directed to be paid 3 months' salary towards compensation for the abrupt cessation of their services. Thus, the process of judicial reforms in India went through several innovative steps, but the result was not on expected lines. The problem of pendency and arrears kept increasing, keeping both the judiciary and the executive bewildered and completely clueless. So, having seen the history of these judicial reforms in the first part, let me now move to the second part of the discussion on the topic. As Justice Challa pointed out, the advent of information technology raised high hopes, and courts started experimenting the use of technology. The Indian judiciary conceptualized an e-courts project in 2005 when the National Policy and Action Plan for Implementation of Information and Communication Technology was presented. This was presented in the year 2005. But it took 8 more years for taking the next step. And the e-courts national portal was launched in August 2013. The 103rd Parliamentary Standing Committee on Personal, Public Grievances, Law and Justice submitted a report on September 11, 2020. The report was titled "The Functioning of Virtual Courts, Court Proceedings Through Video Conferencing." This was the title of the report. The report provided a definition of virtual courts. According to the report, virtual courts mean courts where, number one, plaint and other documents could be submitted electronically, court fees could be paid electronically, evidence can be submitted digitally, arguments can be heard over video conferencing, witnesses can give their testimony remotely over video conferencing, and copies of the orders, judgments, etc. can be made available on the website of the court or through some other electronic means. With a view to remove any misgivings, this report of the 103rd Parliamentary Standing Committee also indicated the difference between virtual courts and online courts. In fact, all of us should understand the difference between virtual courts and online courts. Many times we mix up. The difference indicated by the report are, number one, online courts are one step ahead of virtual courts. The only difference between virtual courts and online courts is that in the former, the hearing is synchronous, but in the later, there is asynchronous form of interaction. This means that in virtual court hearings, the judge, the advocates, litigants, and witnesses need not be available at the time of hearing for a case to progress. In contrast, in online courts, the participants need not be present simultaneously. Arguments, evidence are presented to the judge without the parties being together at the same time. To repeat it, in virtual court hearings, the judge, advocates, litigants, and witnesses should be available at the time of hearing at the same time. In online courts, they need not be available. To its credit, this 103rd report of the Parliamentary Standing Committee identified 3 problematic areas in India. They identified them as the digital divide. This report identified that there are 3 kinds of digital divide in India, which pose a great challenge. Number 1, access divide, which means the non-availability of equipment and infrastructure. Number two, connectivity divide. In many areas, we don't have broadband connectivity in the country. I'm talking about the country as a whole. Then the third kind of divide was the skill divide. Knowledge and the skills required to use digital platforms. I can fairly admit, both on my behalf and on behalf of Justice Challa that I think people like us will fall under the category of skill divide, because we have not mastered this art. This report then recommends certain category of cases which can be permanently transferred to virtual courts, such as Motor Vehicles Act, traffic challan cases, petty offences, etc. COVID-19, all of you know, provided an opportunity not only in India, but throughout the world for technologizing the judicial system. In fact, the United Nations Human Rights Council, in its 44th session, adopted a resolution on July 16, 2020, which urged state members to provide to judiciaries current information and communications technology and innovative online solutions enabling digital connectivity to help enhance access to justice. I should tell you that China has got a model which is very, very fascinating. The model adopted by Chinese judiciary, he makes a very interesting case study. China follows a system called robot justice, wherein the cases are decided by internet courts which run 24/7 under China Global Television Network that does not require anyone to appear physically in the court. Smart court, which China follows, includes non-human judges. There are non-human judges powered by artificial intelligence. People seeking legal action shall register their case on the internet and resolve their matters via digital court hearing. This system in China gives users the chance to communicate and receive court decisions by text or through major messaging services. China's first internet court was established in the eastern city of Hangzhou in 2017, and in 2019, it was reported that users completed more than 3.1 million legal activities using the court system from March to October. More than 1 million citizens were registered with the system, along with approximately 73,000 lawyers in China. The internet court in Hangzhou only deals with cases involving legal disputes over intellectual property, e-commerce, financial disputes, etc. The Department of Science and Technology, in its research on robot justice in China, gave a very interesting example of a proceeding. This is what it says, I quote: a virtual judge is represented by an image in the system of a man wearing a black robe. There is no real person. It's a caricature. That caricature asks, does the defendant have any objection to the nature of the judicial blockchain evidence submitted by the plaintiff? Then the human plaintiff answers, no. We must remember, the plaintiffs and defendants there are human beings. It is only the court which is non-human being. It is only the judge which is non-human beings. Because the non-human beings don't have any dispute and they don't have to go to court. In the China Supreme People's Court has been promoting another system called similar judgments for similar cases through artificial intelligence technology in order to ensure effective supervision of trial activities. Therefore, how best are we going to use information technology for reforming the system of administration of justice is something which both technocrats and people who are stakeholders in the system of administration of justice should come together to decide. So this is what I thought about the second part of my lecture. Having seen the traditional approach to reforms in the first part of the talk, followed by the era of reforms through technology in the second part, let me now move on to the third part of this lecture. As I said at the beginning, a cry for reforms in the manner of appointment of judges to higher judiciary and the way in which their conduct could be disciplined is today at its highest pitch, not merely in India, but also elsewhere. Dear friends, I am deliberately going to avoid a discussion on the debate in India surrounding the collegium system of appointment of judges and the cry of the political executive for scrapping the same. I will avoid that. But let us take a worldwide, what is happening around us across the globe. I'll now take you through a world tour. As judges, we can only take you through a virtual tour to all countries, not physical tour, because that costs money. Of course, Justice Challa can now afford, and sooner or later I'll also catch up with him. On July 23, 2023, Knesset is the unicameral legislature of Israel. On July 23, 2023, Knesset in Israel passed a law, which is popularly called the first judicial overhaul law. The Justice Minister, Yair Levin, celebrated the law as the first step in a historic process to correct the judicial system. This is what he said. The first step in a historic process to correct the judicial system. What is this law about? Which has been passed after 29 weeks of unprecedented public protests in Israel. What happened was, after the present coalition government came to power in Israel, the Justice Minister Yair Levin announced in January 2023 a set of judicial reforms that sought to cut down the powers of the Supreme Court to review laws and to strike them down. The reform proposed was to cut down the powers of the Supreme Court to strike down laws. I am talking only about Israel. Please remember, Justice Minister Yair Levin of Israel said, I quote, Supreme Court's growing intervention in cabinet decisions and Knesset legislation had ruined public trust in the legal system, leading to severe damage to democracy. Please remember, I am quoting the Israel Justice Minister. This is what he says. Israel Supreme Court. Supreme Court's growing intervention in cabinet decisions and Knesset legislation had ruined public trust in the legal system, leading to severe damage to democracy. We go to the polls, vote, elect, and time after time, people we did not elect choose for us. He was indicting the judiciary. Levin said, many sectors of the public look to the judicial system and do not find their voices heard. So these judicial reforms in Israel were in 4 parts. The first, conferring power upon the parliament, Knesset, to override Supreme Court decisions. The second part, taking away the power of the Supreme Court to strike down a law on the standard of reasonableness. The third part, changing the method of appointment of judges. And the fourth part of the reforms enables ministers to appoint their own legal advisors. If I elaborate on the third part of the reforms, namely changing the method of appointment of judges, you may wonder whether I am talking about Israel or some other country you are familiar with. As of now, judges in Israel are chosen by a committee of 9 judges, 9 members. In Israel, there is a committee for appointment selection of judges. This committee comprises of 9 members. Out of these 9 members, 3 are sitting Supreme Court judges, including the President of the Supreme Court. They don't call them Chief Justice, they call them President of the Supreme Court. 3 members are sitting Supreme Court judges. There are 2 representatives of the Israeli Bar Association and 4 members who are elected representatives, 2 members and 2 Knesset members, which means 3 plus 2 plus 4, a 9-member committee. Under the reforms, 2 representatives from the Israeli Bar Association would be replaced by 2 public representatives chosen by the Justice Minister. Otherwise, look at the combination. Judges are selected by a 9-member committee. Out of the 9 members, 3 are sitting Supreme Court judges, 2 are members of the Bar Association. So that is 5. 4 are members of the political executive. Now, in the reforms, majority of the members of this selection committee will be the political executive. Interestingly, these reforms have evoked a lot of protests in Israel in the past 29 weeks. But the reforms also have their own supporters. One of the very leading dailies in Israel, namely the Times of Israel, published an open page authored by a person called Jonathan Green, Executive Director of Israel Law and Liberty Forum. This op-ed contained an argument in support of the reforms. The first argument was that in our country, the Supreme Court has become all-powerful. A closer look at the proposed reforms, this is what this Executive Director said. A closer look at the proposed reforms reveals a measured, justified, and indeed a patently democratic response to the decades of illegitimate judicial overreach. This is what he said. The real democratic deficit, this Green continued, can be found in the past 30 years of judicial supremacy, whereby the court may override the Israeli parliament and has final say on any matter it chooses, despite no actual constitutional anchor enabling such authority. Interestingly, at around the same time when these judicial reforms became the subject matter of heated debate and protest in Israel, something similar happened in our neighboring country, Pakistan. On March 30, 2023, the upper house of the bicameral parliament of Pakistan passed a bill curtailing the powers of the court. Days before the bill was passed, Pakistan Prime Minister declared that history will not forgive us if the powers of the top judge are not curtailed. In his address to the National Assembly, the Law Minister of Pakistan said, I quote, "In the past, it has been observed that suo notice has been taken on petty matters like lack of parking space outside a hospital, submerging of a street in rainwater. Therefore, it is the need of the hour to form a mechanism to ensure transparency." This is what happened in Pakistan. Let us see what happened in Canada. On June 23, 2023, David Lametti, Minister of Justice and Attorney General of Canada, announced that legislative amendments to Judges Act to strengthen the judicial complaints process received royal assent, and these changes have now become law in Canada. The amendments seek to reform the process of handling complaints against judges in Canada, which has been established 50 years ago. Under the new system, mandatory sanctions can be imposed on a judge when a complaint of misconduct is found to be justified, but not serious enough to warrant removal from office. Such sanctions now include, now these are the sanctions in Canada for minor misconducts on the part of judges. Very interesting. Such sanctions now include counseling of the judges, continuing education, and reprimands. Canada has now streamlined the process of inquiring into more serious judicial complaints where removal from the bench could be an outcome. There is what is called the Canadian Judicial Council, CJC, which is responsible for administering the judicial complaints process. This CJC is now required under the reforms to include in its public annual report the number of complaints received and how they were resolved. Let us now take a look at Poland. In late 2019, the Polish Sejm, the parliament is called SEJM. I don't know whether it is called Sejm or Sej or Sem. I don't know. The Polish Sejm approved a law aimed at cabining the structure and functioning of the judiciary. The new law, popularly referred to as muzzle law, not muscle law, muzzle law, empowers a disciplinary chamber to bring proceedings against judges for questioning the ruling party's platform. The law allows the Polish government to fire judges or cut their salaries for speaking out against legislation aimed at the judiciary or for questioning the legitimacy of new judicial appointees. Although the law extends the government's disciplinary powers, disciplinary proceedings against judges are nothing new in Poland. Since Poland's disciplinary chamber was founded in 2017, you must remember, a disciplinary chamber for judges was formed in 2017 in Poland. Ever since then, over 1,000 judges have been targeted in Poland. In a recent report, a group of Polish judges highlighted the repressive activities of the chamber. The report describes instances of judges being prosecuted for engaging in allegedly political activities, such as chairing a meeting where judicial independence is discussed. In other cases, judges were prosecuted for referring questions to the European Court of Justice, which is described as an action of judicial excess by the prosecutors. Therefore, it can be safely concluded that the first two aspects of judicial reforms, namely, number one, the question of providing speedy and a cost-effective system of administrative justice, and number two, the use of ICT in judiciary, there has been positive developments throughout the world on these two aspects, which was covered by me in the first and second part of my lecture. But on the third aspect of judicial reforms, namely on the question of appointment of judges and on the question of disciplining of judges, there has been a lot of acrimony. Whatever is happening around the world, to some extent, gets reflected in our country also. And people have started thinking in some of those countries which I referred to, that judiciary should fall in line and the reforms, all judicial reforms should also be aimed at that. Some arguments, having said that, I should say that some arguments on both sides are very validly made out, but some other arguments are questionable for their validity. I think time alone can provide a solution. With these few words, I thank Mr. Suribabu, his family, for giving me this opportunity to share a few thoughts on the question of emerging trends in judicial reforms. I thank my dear friend Justice Challa and Justice Anil Kumar for sharing the dais with us. Thank you very much.
Thank you so much, Honorable Justice V. Ram Subramanian sir, for your insightful and wonderful collaboration of uh, the emerging trends in judicial reforms. It was very interesting, and we could really get different perspectives from the three parts of your lecture. Thank you so much, sir. Uh, Now we move on to the concluding remarks. I now invite Sri Shyam Padman, sir, Advocate Kerala, High Court of Kerala, for the concluding remarks. Over to you, Shyam, sir.
Thank you, Dr. Sushant. I first of all let me confess that I am not competent or equipped to give any concluding remarks, but I thought I'll share my thoughts on this platform. Thank you very much, Rama Subramanian sir, for that wonderful elucidation and I'd say like presented in a three-tier form, starting from India, going to China, then to different parts of the world, and finally ending up saying that it's for this August Assembly to think about it and come to a conclusion. That was really wonderful, sir. And Kondaram, sir, what can I say? I mean, the way you said that predictive analysis and other things might be a substitute, then I thought like I'll just start off by just reading an article which came in Forbes a couple of days ago, June 22nd. Judge finds 2 lawyers for using fake cases from ChatGPT. 2 lawyers who used fake cases generated by ChatGPT were handed a joint fine of 5,000 US dollars and ordered to reach out to judges mentioned in the fake cases with information about the situation, marking the first major sanctions to come from the use of artificial intelligence in the legal field. In his decision, New York District Judge P. Kevin Castle said Stephen Schwartz, the lawyer who used ChatGPT, and Peter Lodka, Schwartz's co-worker and the attorney who look over the case when it moved out of Schwartz's jurisdiction, consciously avoided signs the cases they were using as examples were fake, therefore acting in bad faith and misleading the court. The good side, the bad side, and the ugly side of technology. And for that matter, I was just reminded of the car test that is being used for identifying pregnancy. Like, I mean, you put a drop of urine, if you get one band, you are pregnant, 2 bands, something like that. And if my urine produces the same single band, will my doctor say that, congratulations, Shyam, would you like to have a boy or a girl? I don't think so, because the science behind is entirely different. For it says that it only means that you got a particular hormone identified by the kit, HCG, I believe, human chorionic gonadotrophin hormone, which says, the science says that a pregnant woman would have a heightened plateau of this hormone. And the doctor would come to a conclusion that you are pregnant or you are suspected of being pregnant. But if in my case, the same science says that if you got a malignant tumor inside, the same result will come. So end of that, the technology is not going to rule. It is a forensic skill of the adjudicating officer, or I'd say, just like in the medical field, it's a doctor to come to a conclusion depending upon the surrounding circumstances, corroborative materials that has been placed to come to a conclusion. I strongly believe that technology may not substitute the human. I mean, there is not going to be a dehumanization of the justice dispensation mechanism, because it requires different skill sets, it requires different permutations and combinations. Maybe in the long run, AI may be able to assist, but it can never be a substitute. It's my humble submission before this August Assembly. I would say that today's lecture, and that too by the person so wonderfully introduced by Justice Anil Kumar sir, was that it's akin to rebooting the judiciary in the E mode, number one. Re-understanding or the concept of judge, the judiciary, and the court in a different perspective altogether. We always identified court as an institution, as an establishment, or a structure. But I believe that if we go through the different definitions that's available in our law and also in different jurisdictions, it is not an establishment, it's not a structure. It is where the new normal makes us rethink whether it should be just like opening and closing of courts limitation act, we have something. But I don't think any other place we have any mention of a specific structure or a building. So the changing circumstances, the change in the perspective, the change that has come in the justice dispensation compels us to think in terms of justice dispensation from, it need not necessarily from a place, but it should be from a source. So in this context, the three, one is overview of the reforms in the past, wherein there was a knee-jerk reaction of excessive tribunalization as a panacea to all maladies. Then come the use of information technology assisting the existing system, augmenting the existing system, and ways and means of curbing the maladies that is there in the existing system. So I would say that from the introductory remarks by the host, Dr. Sushant, the emotional welcome by Sri Suribabu sir, wonderful encapsulation of by Justice Kondaram sir, a befitting introduction of the speaker by Justice Anil Kumar, a tribute, just like what Rama Subramanian sir said, by the incoming judge to the outgoing judge, or the new era to the, I won't say the old era, because Rama Subramanian sir can never be part of an old era because he's part and parcel of us. We had a very interesting, enriching, and constructive evening. The fallacy of mistaking reforms as having more tribunals, etc., dispelled. The digital divide, whether it's technological, whether it is information-wise, if it is what do you call a device-wise or whatever it is, all those things which were covered so beautifully, and the China model of internet or digital codes, the exposure to that was enlightening. And I would say that regarding that appointment of judges, it was really wonderful. I was just wondering whether we could have a coffee vending machine. Put in the facts and you get the coffee underneath. Like, I mean, if that was possible, there was no need for anything in between. Like, but wonderful indeed, sir. And we live in a country, sir, wherein oppression of geography is a fact. So you have manned the apex court, but for somebody from South India to reach it's an impossibility. It's a reality even today. So unless and until technology and web-enabled technology and other things comes to the aid of the common man to reach the apex court, Article 21 for that matter, or any other article or any other constitutional, I say that guarantees would be just be in paper. So if right to life takes in right to access to justice, right to have speedy trials or early access to justice, if it's to be actualized, I believe a person, I won't even say South India or for that matter any other place. Let us take Lakshadweep for that matter, wherein we have that special provision for even limitation, that during monsoon they don't have limitation because that stands as a standstill. Taking note of the fact that their inability to come to the mainland and access justice. So I believe when we speak about emerging trends in judicial reforms, it should be centered around the stakeholders, starting from the person whose grievance is sought to be ventilated, number one, and the constitutional mandates of equality, of solidarity, of whatever it is. If it is to reach the common man to the grassroots level, we'll have to change along with the changing science and technology. I'm just reminded of one case wherein it went up to the apex court, sir, wherein in 138 case, notice was sent through fax. The defense before the magistrate, before the High Court, which had went up to the Supreme Court, was that fax is not something contemplated under law. You should have sent it by registered post acknowledgement due. And the bench headed by H.T. Thomas said, where in the Act of Negotiable Instrument Act, it is said that it should be, it's only intimation to be given. Thankfully, in that case, there was no case that fax was not received, because otherwise it would have, I mean, we should have a proof of delivery and things like that. Only thing they had agitated was that even at that point of time, it was somewhere in the 2000, I believe, or even prior to that, you should not have sent it by fax. You should have sent it by registered post, or I'd say that snail mail should have been used instead of fax. And finally, in that case, it was said that when you deal with interpretation of statutes, the reform starts with interpretation of statutes as well. You will have to give sufficient leeway for the advancement in technology, social norms, or for that matter, even meaning of words. And for that matter, we had Section 4, I believe, of Hindu Minority and Guardianship Act, where it was said that firstly the father and after him the mother. And after him was sought to be interpreted as after the death. But when gender equality came in the international scenario and the reforms started percolating to our system, the Apex Court said that in the absence of, not after death. And that's definitely before even that particular provision is under challenge before the constitutional bench of Apex Court, wherein even that could be somebody has to wait in the queue. So, sir, today we were exposed to thoughts. We are not looking for answers, but we were exposed to certain thoughts which will rekindle each and every member of this August Assembly to think, contribute in whatever manner it's possible for the reform of our judicial system, whether it be in the form of disposal, whether it be in the form of adjudication, whether in the form of new acts coming in different languages, which has come yesterday or day for that matter, wherein we'll have to rethink of understanding what IPC, CRPC, or for that matter, Evidence Act is. But end of the day, sir, all of us are thinking in terms of having an effective and public-oriented justice delivery system, which I'm sure that workshops and talks like this, and especially thanks to Suribabu sir for initiating this dialogue, so that all of us, and by seeing this in different platforms, others also would think and constructively contribute to have a better tomorrow. And with those thoughts, I'd say that thank you very much. Okay.
Thank you, Shyam sir, for the concise overview of the entire event. Thank you so much. It's been, in very simple and concise manner. We could just, your summarization was very, very good. Thank you so much. Now, we move on to the vote of thanks by Sri Suribabu Samudrala sir. Over to you, sir.
Sir, Shyam sir, one issue I just want to bring you to your notice. Justice V. Rama Subramanian sir, as he then was when he was presiding over the Telangana High Court, he gave a judgment regarding the service of a notice by an email, service of a show cause notice by email, where the enactment has not brought out the amendment substituting the service through email. My lords have held that it is not a proper and valid service. It was in my own case, Honorable Justice Ram Subramanian sir delivered judgment. Anyway, sir, thank you very much, sir, for enlightening us with the tribunalization of justice, enlightening us on the robust justice system and usage of artificial intelligence in the judicial system, and you have taken us to the tour of all the other countries where judicial reforms are being introduced and are taking place in Israel, Canada, then Holland, etc. And thank you so much, sir, and for accepting my invitation, personal invitation at too short a time, and making it convenient to deliver this memorial lecture. It is a memorable lecture to us, and we have got enlightened. Of course, you have thrown the subject very open to all of us to rethink about what is the judicial reforms which have to be taken place in the Indian judicial system. And thank you so much, sir. Thank you, Kodanda sir, for accepting my invitation to give the introductory remarks. Thank you, Honorable Justice Anil Kumar sir, for introducing the speaker of today's session. And I also thank Shyam Padman sir for initiating the concluding remarks. And I also take this opportunity to express my sense of gratitude to all the participants, and particularly the judges from Telangana, Andhra Pradesh, and Kerala High Courts, and Justice T. Vinod Kumar from Telangana High Court, Sri Honorable Justice Aliseti Lakshmi Narayana from Telangana High Court, U. Durga Prasad Rao, Honorable Justice U. Durga Prasad Rao from Andhra Pradesh High Court, Honorable Justice Raghunandan Rao from Andhra Pradesh High Court, Honorable Justice N. Jay Surya from Andhra Pradesh High Court, Honorable Justice M. Ganga Rao, retired judge from the Andhra Pradesh High Court, and Srimati Jyotirmayi from Andhra Pradesh High Court, then Chaitanya Kangan from Kerala High Court. And thank you so much. And it was a very good session we had. And I thank Honorable Mr. Shyam Padman for making us our dream come true by hosting this on his platform, Littles. Thank you so much. Thank you one and all. And all the participants who have joined this session, I really thank you from bottom of my heart. And I thank all my family members for giving me this opportunity to host this program. Thank you so much. And I seek the blessings of my father. Thank you so much.
Thank you.